Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Hey there, and welcome back to the deep dive. Sometimes the biggest shifts aren't about some flashy new gadget, but about getting the rules right, the basics.
Exactly, especially when it comes to something like innovation.
Right. And today we're jumping into patent law, specifically a Supreme Court decision that really fundamentally changed how clear you have to be when you describe your invention.
Yeah, it's all about striking that balance, isn't it?
Yeah.
Rewarding the inventor, but also making sure everyone else knows where the lines are drawn. So progress isn't stifled by confusion.
Precisely. It's about making sure the description is clear, not just for lawyers maybe, but for the people actually building things. So let's unpack Nautilus versus Biosig.
Definitely. This case set a new standard for clarity, trying to define what's truly new and, just as important, what's still, open territory for others.
Our mission today is to really dig into this judgment. We'll cover the case details, its path through the courts, the arguments, and critically, why this decision still matters so much today for anyone involved in tech or invention.
Sounds good. Let's get into the details.
Okay, so to really get this, we need the backstory. The case itself is Nautilus, Inc. v. Biosig Instruments, Inc. The Supreme Court decided it June 2nd, 2014. Case number is 13369.
And it was a unanimous decision, which is pretty significant in itself. Justice Ginsburg wrote the opinion.
The main players were Nautilus as the petitioner. They were challenging the patent, and Biosig Instruments as the respondent, defending it. We don't have specific lawyer names from our source, but it's the companies and the tech that are key here.
Right, and the tech is actually quite interesting.
It is. At the heart of it is Biosig's patent, U.S. patent number 5,337,753. It's from back in '94, invented by Dr. Gregory Leckman.
And it was for a heart rate monitor, specifically the kind you find on exercise equipment.
Now, you might think, okay, heart rate monitors, we've had those for ages. But the problem, especially back then, was accuracy during exercise.
Yeah, because when you're gripping handlebars, your muscle signals, the EMG signals, can interfere with the heart's electrical signals, the ECG signals. They kind of drown them out.
Makes sense. So what did Dr. Leckman figure out?
Well, his invention was pretty clever. It aimed to filter out that EMG noise. It used a key difference. ECG signals from your left and right hands have opposite polarity.
Okay.
But the EMG signals, the muscle noise from both hands, tend to have the same polarity.
I see where this is going.
Exactly. So the device measures signals from both hands and uses something called a difference amplifier to basically subtract the identical EMG signals from each other.
Leaving a cleaner ECG signal behind. That's smart.
It really was. It addressed a real practical problem with the prior art.
So where did the legal trouble start? The patent describes electrodes mounted in spaced relationship with each other on the handlebar. That phrase became important.
Very important. That phrase, in space relationship, was right in Claim 1, defining the physical setup.
And the lawsuit. Biosig sued Nautilus. Why?
Biosig claimed Nautilus was infringing this patent. Apparently, Nautilus had acquired Stairmaster, a company Biosig had previously shown its technology to. Biosig argued Nautilus was using the tech in their machines without a license.
Okay, so a pretty standard infringement claim initially, but the legal path got complicated, right?
Oh yes, it wasn't straightforward. First, Nautilus actually challenged the patent's validity back at the Patent Office, the PTO.
On what grounds?
They argued it wasn't actually new, that it was anticipated by prior art. Standard procedure.
And during that process, Dr. Leckman, the inventor, had to explain things.
He did. He submitted a declaration saying, look, you can't give one single exact spacing measurement that works for everyone, but someone skilled in the field, an engineer, could figure out the optimal spacing through trial and error to get the best EMG cancellation.
And the PTO?
They bought it. In 2010, they confirmed the claims were patentable. You'd think that would be the end of it.
But it wasn't. Back in court, the district court in New York had to figure out what in-spaced relationship with each other actually meant. That's claim construction. Right?
Exactly. And the parties disagreed. Biosig said it was about the space between the live and common electrodes. Nautilus pointed to Biosig's own statements to the PTO and argued it meant a space wider than the electrodes themselves.
So what did the district court decide?
They landed on a more general meaning, a defined relationship, but didn't tie it specifically to electrode width. But then Nautilus made another move.
Summary judgment.
Right. They argued, okay, even if that's what it means, the term spaced relationship is still too vague. It's indefinite under Section 112, Paragraph 2 of the Patent Act, the part that requires claims to be specific.
And the district court?
They agreed with Nautilus. They said the phrase did not tell the court or anyone what precisely the space should be or even give any parameters, found it too indefinite, invalidating the claim.
Wow. So victory for Nautilus at that point.
Temporarily.
Yeah.
Because Biosig appealed to the Federal Circuit Court of Appeals. That's the special court that handles all patent appeals.
And they have their own way of looking at indefiniteness.
They did. Their standard was that a claim is indefinite only if it's, quote, not amenable to construction or insolubly ambiguous. Much looser, really.
So basically only if it's completely impossible to figure out.
Pretty much. And under that standard, the Federal Circuit reversed the district court. They said, no, the patent documents, the claims, the description, the back and forth for the PTO, they provide inherent parameters.
Like what?
Well, for example, the space couldn't be wider than a hand, obviously, and it couldn't be zero. They felt someone skilled in the art could figure it out based on the context.
So the patent was definite again. But you mentioned some nuance even there.
Yeah, Judge Schell wrote a concurring opinion. He agreed with the outcome. The patent was definite under their standard, but his reasoning was a bit different. He thought the district court's idea of a fixed spatial relationship was clear enough on its own. He didn't think you needed to tie that specific phrase directly to the function of removing EMG signals. He felt other parts of the claim took care of the functional aspect.
Interesting. So even the judges agreeing on the result didn't quite agree on why, which kind of highlights the whole problem, maybe.
Absolutely. It perfectly sets up the big question that went to the Supreme Court, which brings us right to the core legal question. What is the right standard for definiteness under the Patent Act, specifically 35 U.S.C. Section 112, Paragraph 2?
Right. That part requires claims to particularly point out and distinctly claim the invention. Was the Federal Circuit's insolubly ambiguous test good enough? Did it meet that requirement for precision?
That was the whole fight. How much fuzziness is acceptable in a patent claim?
So Biosig, defending the Federal Circuit's ruling, what was their take?
They argued, essentially, that you just need reasonable notice of what the invention covers. They felt space relationship, read with the whole patent, gave enough clues for a skilled person.
And that insolubly ambiguous wasn't really as loose as it sounded.
Yeah, they kind of framed it as shorthand for a deeper analysis the Federal Circuit was already doing. Basically, it works, don't fix it.
Okay. And Nautilus, challenging it, what was their argument?
Nautilus argued that if reasonable people could interpret the claim's scope differently, then it's too ambiguous and should be invalid.
They thought the Federal Circuit standard was way too forgiving.
Exactly. They argued it created this zone of uncertainty. You didn't know exactly what was protected and what wasn't, and that uncertainty actually hurts innovation because people are afraid to experiment near the fuzzy boundaries.
And they used the disagreement among the Federal Circuit judges as evidence.
Precisely. They said, look, even these expert judges can't agree on what it means. How can a regular engineer or competitor be expected to know?
It really highlights that tension. How precise do you need to be? And who's the audience, the inventor, the judge, the engineer down the street? Both sides seem to have a point.
Absolutely. And that's why the Supreme Court had to step in and provide, well, clarity on clarity.
All right, so the moment of truth. The Supreme Court steps in. What did they decide?
They didn't side entirely with either party, in a way. They vacated the Federal Circuit's judgment. That means they threw out the lower court's decision.
Threw it out. So victory for Nautilus, then?
Not exactly. They didn't rule on whether Biosig's patent was indefinite. Instead, they sent the case back down, remanded it to the Federal Circuit.
Why? To do what?
To reconsider the case using a new standard for definiteness. They essentially said, Federal Circuit, your insolubly ambiguous rule is wrong. Here's the correct test. Now apply this test to the patent.
Okay, so what is the new standard? This is the core holding, right?
Exactly. The Supreme Court held that a patent claim is invalid for indefiniteness if its claims, read in light of the specification and the prosecution history, fail to inform those skilled in the art about the scope of the invention with reasonable certainty.
Reasonable certainty, not insolubly ambiguous.
Right. They explicitly rejected the Federal Circuit's standard. They found it tolerated too much imprecision. It let claims survive, even if they were quite murky, as long as they weren't completely impossible to figure out.
What was the court's reasoning for demanding reasonable certainty? You mentioned Justice Ginsburg recognized a delicate balance.
Yes. On one hand, the court acknowledged language isn't perfect. Some uncertainty might be unavoidable, maybe even the price of encouraging innovation with new concepts. And patents are written for people skilled in that specific field, not necessarily the general public.
So they weren't demanding impossible mathematical precision.
No. But, on the other hand, they heavily emphasize the public notice function of patents. A patent has to be clear enough to tell the public what's off limits and what's still free to use or improve upon.
To avoid that zone of uncertainty Nautilus talked about.
Precisely. The court said the Federal Circuit standard allowed too much ambiguity, creating that zone where companies fear infringing unclear patents, which chills innovation. They even said phrases like insolubly ambiguous could leave everyone at sea without a reliable compass.
So reasonable certainty is meant to be the compass. Clear enough for skilled people to understand the boundaries, while admitting perfection is impossible.
That's the idea. It demands more clarity than the old standard, but acknowledges the realities of language and technology. It aligns with older precedents, too, like mineral separation, which talked about needing certainty that's reasonable, having regard to their subject matter.
And you mentioned it connects to the practical impact.
Absolutely. It's not just legal theory. It's about inventors and businesses knowing where they stand, allowing them to innovate more confidently.
And because the Supreme Court is a court of review, they set the standard but let the Federal Circuit apply it first to Biosig's patent.
Correct. They established the correct legal rule and sent it back for application.
And this wasn't pulled out of thin air. It was based on existing law and cases.
Definitely. It's grounded in Section 112, Paragraph 2 of the Patent Act, and they cited a whole line of cases. Festo for the balance in prosecution history, Mark Koyman for clear boundaries, United Carbon for the zone of uncertainty concept, and minerals separation for reasonable certainty. They synthesized these existing ideas into the new, clearer standard.
Okay, so the dust settles. The Supreme Court sets this new reasonable certainty standard. What's the big takeaway? What's the lasting impact on patents and innovation?
Well, it's huge, really. It directly overruled the Federal Circuit standard that had been used for a long time. It effectively raised the bar for patent clarity.
So inventors and their lawyers now have to be more careful, more precise when writing patent claims.
Absolutely. The burden shifted more onto the applicant, to be clear. You can't rely on a court maybe figuring out a fuzzy claim later. You need to provide that reasonable certainty from the start, thinking about how someone skilled in your field will understand it.
Which presumably means the Patent Office examiners should also be applying this stricter standard during review.
That's the implication. It pushes for more rigorous drafting and examination, aiming for clearer boundaries right from the beginning.
And the goal is less ambiguity, fewer costly lawsuits down the road.
Hopefully. Clearer patents should mean fewer disputes about what they actually cover. It strengthens that public notice function we talked about.
So if we had to boil it down to one absolutely critical takeaway from Nautilus v. Biosig,
I'd say the key takeaway is this. The Supreme Court mandated that patent claims must define the invention with reasonable certainty for someone skilled in the art. They threw out the old, much looser, insolubly ambiguous standard.
and that shift fundamentally changes how patents need to be written and interpreted.
Fundamentally, it's about ensuring patents clearly communicate the boundaries of the invention, serving both the inventor and the public good by fostering a more predictable environment for innovation.
And that wraps up our deep dive into Nautilus v. Biosig. It really shows how a legal standard, seemingly just words on paper, can have such a ripple effect through the entire world of invention.
It really does. That reasonable certainty standard aims to make the lines clear, not just for courts, but for the innovators on the ground.
It's a push for more transparency, which ultimately should help everyone involved in creating new technologies.
Exactly. Trying to get closer to that ideal, maybe unattainable world where IP boundaries are crystal clear. This decision forces inventors to think hard about how they define things, especially in fast-moving fields.
Which leads to a great question to think about. What aspects of today's cutting-edge inventions, maybe in AI or biotech, do you think are the absolute hardest to pin down with that required reasonable certainty?
That's a tough one, and definitely something innovators grapple with daily.
A fascinating thought to leave you all with. Thanks so much for joining us on this exploration of patent clarity. We hope it gave you a new perspective on the language of innovation.
Until next time.
Keep exploring, keep questioning, and keep being curious.